Hello and welcome to the News Minute and News Laundry. I'm Nidhi Suresh. On December 9th, Atul Subhash, a software engineer in Bangalore, took his own life. He left behind a 24-page suicide note and an 81-minute video that has now gone viral on social media. In it, he accused his wife, Nikita Singhania, her mother, and her brother of nudging him and harassing him and almost forcing him to take his distressing step. Ever since this case came into the news, there's been an ongoing debate about Section 498A of the IPC, which is now as Section 85 and 86 in the BNS. Today with me is Senior Supreme Court Advocate Vrinda Grover. Thank you so much for having us in your office to have this conversation.
Sure.
So Vrinda, before we go into the conversation and the debate that's happened since this case, can you help us understand what is the context of Section 498A? Why was it validated in the law in the very first place?
Absolutely. I think it's always important to go back to the history to understand the present. So 498A was introduced into the Penal Code in 1983. What was the social reality which compelled Parliament to pass such a provision, amend the Indian Penal Code? At that time, as media was reporting and as we were hearing, a lot of women were being treated with a lot of cruelty, harassment for dowry and otherwise. In fact, soon after that, there was another provision that was added, Section 304B, which is otherwise known as dowry death. So a separate offence was carved out for dowry death and a separate offence was carved out for cruelty by husband or his relatives. Why did this emerge? Because in the Indian social context in particular, partly due to dowry and even otherwise, it was found that women were facing cruelty of a nature and a gravity that was taking a serious toll both on their life and on their physical and mental health. And when a woman typically marries in India, given our patriarchal system that we have, and the entire institution of marriage is actually how patriarchy manifests itself, even though we may revisit it and people may reformulate it in their own ways, the woman moves to the house of the in-laws. She then begins to live in a home where she is surrounded. There may be more nuclear families today, but we are also talking of the 1980s, where joint families were far more common, and they continue to be very commonplace in many parts of the country. And therefore, the woman is actually entering a household where she barely knows anybody. Arranged marriages were much more common. Even today they are. So the woman is actually going to start living in a household where she barely knows anyone, and therefore there is a possibility, if things are not going well, for her to be in a hostile environment. And that is why this law came about. In fact, I recall very clearly that the women's movement at that time had highlighted the issue of both dowry death, dowry harassment, and as we know, the Dowry Prohibition Act predates it. From the 60s, this law has been in place. Of course, the law has been ineffective ever since. As we do know, dowry continues to be a part of our social, cultural practice in all classes, in all castes, and if I may say so, actually in all religions today. And we may pass it off as gifts, we may pass it off as love and affection, but
Lena dena.
Yeah, lena dena, and these are just cultural things, and they're giving it, the girl's family is giving it out of their free will. But it's very interesting. The transaction is always one-sided, right? The girl's family, the bride's family, her parents in particular, gives all the expensive gifts, and the main gifts are given in that form. So while we may today be discussing abuse of law, misuse of law, let us not for a moment forget that dowry continues to be a pervasive social practice in almost all marriages, barring very few, across the country. And we don't seem to hear a lot of umbrage from anyone on that. It's not just the courts, but even in social commentary, we don't hear that any longer. Going back to the 80s, when the women's movement began highlighting, because they were hearing from families, distressed women, as to what was going on inside the matrimonial home. I remember being part of a street play. It was called Om Swaha, which, as you know, comes from the religious havan that is performed, particularly also at the time of marriage and even otherwise. This was a play that had been performed by many feminists across the country. And we would go to different parts of the city as a group and perform this play, which showed how a daughter-in-law was burnt to death in her matrimonial home, and what was the silences that surrounded, both socially, within the family, her compulsions, why was she coerced into such a situation, how helpless she was. When we perform this in public places, I have a clear recall how many people quietly would come up to us and say, "This is happening to my sister. Can you help us? I know my neighbor is actually harassing their daughter-in-law." So it was a lived reality of women.
And there was a term called kitchen deaths, right?
Yes, which was talked about, where stoves were. At that time, there were these burner stoves. Gas was uncommon, and gas was in more privileged homes, and mostly people cooked on stoves. And it was quite a strange coincidence that across the country, the stove would burst only and only the daughter-in-law was in the house. And of course, as we know, science and technology doesn't usually care about women. Maybe those stoves were not very good, but of course nobody was going to bother, because surely men were not cooking on stoves in the home. They may be cooking commercially. So the stove deaths leading to dowry deaths, leading to death of daughters-in-law, all this would be shrouded in mystery, because who will give the evidence of what happened inside the matrimonial home? Who would know? Only the family, which may be complicit in the death, in the homicide or the suicide, or the cruelty that she is suffering. Again, given the patriarchal norms of society, the whole business that women are told. Today when we live in urban areas, we think these are not aspects of women's lives. Actually, despite the look of modernity that we in India today have acquired, whether it be in our language, our clothes, etc., the woman should get married and go to the husband's house, and from there only her dead body, that her arthi should come out, is not something that the modern day parent is not telling the woman, their daughter. These are very, very deeply ingrained norms in our society. Women are encouraged not to complain to their families when they are suffering, and they are told, anyway, this is wear and tear of family life, you should adjust, it's all very new, you have to all both learn to accommodate. In fact, whispers of that can be seen and heard in judicial verdicts also. That was the scenario in which 498A was introduced in the Indian Penal Code. It marked a very important place where there was a recognition of cruelty within marriage, because as has been said even in recent judgments, marriage is a revered institution in India. Marriage should be a revered institution, any union of any two adults. Of course, here we have a heteronormative form which persists. Any such association may or may not be revered, but there should be some principles which underlie it. Now, if it is based on violence, if it is premised on violence, and on the violence that is inflicted on the bodies of women, or actually the extraction of labor of women, including social labor and reproductive labor, then we need to interrogate this category of marriage. There is a hesitation in our society, and I would say that courts actually have been extremely reluctant to talk about that. Why can we not interrogate and question the fundamentals of the institution of marriage and the institution of family? If equality and mutual respect are not the premise, then you are not going to build an institution based on domestic violence and other forms of abuses, those institutions need to be questioned. That is the reality in which this came about, where cruelty was recognized, and very importantly, not only in the context of dowry, but also cruelty. You may not bear a son. That could become a reason for a lifelong taunt, asking you to go kill yourself so that we can get another wife who will then create the progeny which the family wishes for. Your complexion may not be what that family, everybody's supposed to be fair, apparently. All women are supposed to be fair. Men, dark men are great, but women all have to be born fair. So that can become a cause of a taunt. So not only related to dowry. And it recognized that mental and physical cruelty that is inflicted within the matrimonial home by the husband and or his relatives.
So what essentially I'm hearing is that this is a very gender-specific.
Absolutely.
But of the recent debate, there's been a call to make this 498A gender-neutral. Men's rights activists have said that this should be accessible to men as well if there are cases where women are inflicting violence on men within the realm of the marriage, right? What do you think? Can this be made a gender-neutral law at all?
So as I explained the history of this, and that history, as I again said, insofar as dowry is concerned, insofar as women moving to homes of their husband and in-laws, none of that has changed. It's pretty much the same. Yes, in urban areas today, couples may set up their independent homes. Women may well be working, or people may form their own mutual alliances. So there may be some change, but that's not the norm. That's not the way larger society is structured. So the larger society structures or practices or inequalities, which to my mind stems from patriarchy, has not altered. When you refer to them as men's rights activists, maybe we should call them husbands' rights activists. They're actually not speaking for men. You know, you have a male journalist in Chhattisgarh who has just been found, his body has been found dead after he exposed a scam. I don't hear any men getting agitated. I only hear journalists speaking up for him. So there are husband rights activists. So then these husbands are plagued by something. What is it that they are complaining about? And therefore they don't want these laws. See, what is the purpose of law? Law notices, observes certain inequities in society. Law has to step in to attempt to create an equalizing space, whether it is through 498A, whether it is through the rape sections, which prohibit and punish for rape, the domestic violence law, POCSO for children because of their vulnerability. You have the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act. All these are ways in which law steps in to create equity, recognizing and acknowledging inequity in society. Now, how do we therefore deal with this demand for gender neutral? It's not a new demand. It resurfaces each time. And before I go to that demand, the loss of any and every life lost unnaturally is deeply unfortunate, and whatever amends should be made to see that such life is not lost. That is a principle to which at least I would adhere. Having said that, the Atul Subhash case, a couple of other incidents which have caught the attention of the media, and one of them has left a very extensive note in which I'm afraid some parts of that letter actually may even be saying it's all right to now and then inflict violence against women. Just because a dead man has said it doesn't mean we can't, since that is the subject of the controversy, one will have to look into those aspects also. According to the NCRB data, in 2022, 6,450 women, as per their record, are cases of women under 304B, which is dowry death. So therefore, there have been 6,450 dowry deaths in India in 2022. So dowry is not something that was happening in medieval India. which would be roughly about 17 to 18 women dying either due to suicide or homicide every day related to dowry. And I'm talking of death now. I'm not talking of cruelty only or harassment. So these are figures which are reported figures, recorded figures. These are not even cases that we do not know of. So that is the reality that we are still facing. When a discourse is structured, a narrative is created, it is usually those who are in social and perhaps economic dominance who are able to structure a discourse. The fact that this discourse leads to a conversation of should there be a gender neutral law, while being oblivious that till 2022, 17 to 18 women are being killed for dowry in this country. Why is that not causing setting up alarms across this country?
In fact, the counterpoint to that from men's rights activists has been that there are a huge number of suicide rates of men in India. In fact, it's more than women in India. Although News Minute and News Laundry has done a story by Azifa and Fatima where we look at what the data really says about the cause of this death. You can read it on our website. In fact, farmer suicides are much more, and there they don't even list a reason. It just says farmer suicides.
Right, but they are male farmers or male agricultural laborers.
Yes.
That's why I'm saying we are going to call them husband rights activists. And only, of course, a farmer can also be a husband. But you have to, these are people who are only there, they don't care if a farmer dies. They are exploiting statistics. And actually, anybody who can exploit statistics of death, there's very little to be said about them. But coming back to the gender neutral issue, again, as I said, not a new issue. When the Protection of Women from Domestic Violence Act was enacted in 2005, it was challenged in the Delhi High Court that it should be gender neutral. After all, women are known to have slapped their husband. Maybe. I'm not disagreeing. You see, when law is made, will every individual case be taken into account? Or is law made on certain, there are certain social practices, habits that are observed in society. And the law is then developed alongside with that kind of evidence. And there is huge evidence in this country of women being battered and beaten, whether they are wives or mothers or sisters or daughters. Therefore, a gender-specific law. When this was challenged, on this very ground, the Delhi High Court struck down that challenge and said, no, you have to see what is commonplace happening in society and who needs a special law for protection. Let's come to the story of, after all, women can also inflict. So is the man without legal protection? Is the question one will have to ask. Dowry is not given by the husband. Not in the past, not in the present. Dowry is a pernicious feature of our social fabric and culture, which we need to remove and erase. But if you see the kind of ostentatious weddings that are taking place, it is extremely unlikely that this is going away anytime soon. And we don't hear any comment even from the judiciary on that aspect anymore. The more, it's now not even a 2-day affair, it's like a whole week prolonged activities that are happening. So dowry is gender specific. Domestic violence is gender specific. Therefore, issues of cruelty related to that and the shift of the woman into the home of her husband and in-laws is what creates that isolation for her. So therefore, to say it should be gender neutral is actually a little misleading. And again, men are not without protection of the law.
Yeah, I think that has also been a big question. In cases of misuse, how does the innocent man get protected?
Okay, so in case of any misuse of any law or any legal provision, here we are talking of 498A, now section 85 and 86 of the BNS. The person who claims that we are falsely implicated, how does anybody get protection? the only way you get protection. So let's break this down, because the whole thing is women are, and I'm sorry, the court has contributed to this discourse. If you read the judgments of the court, there are some very interesting phrases that are used. It is common experience that women are filing false cases. Disgruntled wives are filing false cases, misusing the law. These cases are filed on trivial issues at the heat of the moment. They are filed to wreak personal vendetta on the husband and the in-laws. These are phrases that are used. Let me latch on to two specific things that courts have said. And I think this is something that needs to be carefully thought about. Common experience and commonly believed or commonly acknowledged phrases to this effect. Whose common experience is this? When the courts, let's look at the judgments in which this was spoken about. First, in 2005, we had the Sushil Kumar Sharma judgment, where actually it was said that 498A should be struck down because of misuse. And the court very categorically said, just because it is liable to misuse or it is possible to misuse a legal provision, it will not invalidate the legal provision. And that there have to be other ways in which the misuse, abuse needs to be checked. And the court was very clear. The Supreme Court said in 2005, the possibility of misuse will not render a legal provision unconstitutional. What was the case before the court? It was a case, if I'm not mistaken, of an anticipatory bail. So it's an individual case with individual facts only of that case before the court. Then you have much later, you have the Areesh Kumar case, in which it was a case where of summoning the husband as an accused. Again, an individual case and individual facts of that case before the court. No other material is before the court, where the court said arrest is not to be made. Then you come to 2017-18, when the Rajesh Sharma case, where they said there's misuse taking place and no arrest is to be made, go to the Family District Welfare Committee. So, almost parallel with the Rajesh Sharma judgment and the same bench of the Supreme Court. The Rajesh Sharma judgment, as I said no arrest under 498A, set up a district family welfare committee, send them there and let them deal with it. And the exception was made for women. If there was physical injury, then of course the police should proceed. Now, almost at the same time, there was another judgment by the same bench in the Supreme Court in the Dr. Subhash Kashinath Mahajan case, which dealt with the Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act. This was a case under caste atrocities, where there was a challenge made that, and because under the POA Act, anticipatory bail is not granted. And so they said bail, it should be granted because this law is being misused by the scheduled caste, and public servants and others are being falsely implicated, and since there is no scope for anticipatory bail, they are arrested. In this judgment too, the same bench actually used a phrase like, it is publicly acknowledged that the Prevention of Atrocities Act is misused. Now again, where is this data and information about misuse? In fact, I would say it is common experience that scheduled castes and scheduled tribes don't file cases because they fear the legal system. And the court changed, again in this, the court changed the law and said there will be no arrest made of a public servant without seeking sanction from a senior police officer or of a non-public servant person without seeking permission from a different rank of a senior police officer. So in both cases, here one, the law is meant to protect women against violence in the matrimonial home, and in the other, it is to protect scheduled castes and scheduled tribes. In both, almost at the same time, a few months apart the judgments are, they prohibited in this arrest in both. Now look at, so here are two of perhaps the most vulnerable groups in Indian society, which the Supreme Court said no arrest to be made in case of violence against them or atrocities in the case of caste. This led to a huge furor in society insofar as the scheduled castes are concerned. There were protests across the country. And it's an interesting, if you look at it, as I said, almost the same time the 498A order was passed in Rajesh Sharma, women do not even have enough of a voice. And they don't form a political constituency like that, that they would be out on the streets. There were protests, people wrote about it. Many of us expressed concern that what is this family welfare committee going to do now? But there was no, insofar as this Mahajan judgment was concerned, there were protests across the country. Political parties took positions and Parliament amended the SC/ST Act to say, to strike down this judgment. And then came another judgment which said, of Prithviraj Chauhan, which said Parliament, because the new provision which struck down that you will have to take permission was then challenged in a judgment called Prithviraj Chauhan, which another bench heard. And the bench said no, that Dr. Mahajan judgment has been set to rest. Now the SC/ST Act, Atrocities Act, the change that the judgment had brought about will not survive after the amendment. So it was restored, the protection of the law through a parliament intervention, through protests which rocked the country, where every political party was compelled to take a position. Almost simultaneously it happened with women.
Yeah, and despite making up such a huge population of the country,
we are not a political constituency. And while I totally support the position that the SC/ST groups took, and I disagree with the judgment of Dr. Mahajan where they said do not arrest. I think the amendment that was brought into the law was correct, and setting aside the judgment was correct. I think there are two things happening here. The same bench is unable to understand marginalized, oppressed, vulnerable groups, which speaks to perhaps the composition of our apex court. And I think when we talk about judicial anxieties, it is also a reflection of judicial composition, particularly of the higher, in the Supreme Court. Because the experiences come from our own lived experiences or those who are our family, friends, acquaintance, etc. But what is also interesting to observe is that while rightly so, the Dalit community was able to, the SC community was able to mobilize, and compelled political parties to take a stand against the atrocities that are inflicted on them. Women were unable to even do that. Yes, the judgment set aside the Rajesh judgment, the Social Action Forum for Manavadhikar. But in terms of what is your, how in society, what is the kind of weightage you have to change things? I thought it was very telling, since these two things were happening almost simultaneously in time.
But even in the case of SC/ST Act atrocities, even now, for example, I remember when we were reporting on the Hathras case in 2022, the UP government actually argued in court that this doesn't fall under SC/ST Act violation, and it is actually a gender crime.
In fact, there is a 2015 amendment of the Protection of Atrocities Act, which specifically talks about sexual violence and gender-based violence against Dalit women. So of course it falls under, but there the law is strict. You have to, and there is a strict procedure which nobody wishes to follow, not the state. And unfortunately, courts are talking about misuse without, I mean, you can't write a phrase like, it's publicly acknowledged that this law is misused. I would challenge, it's publicly acknowledged that this law is not being used. I mean, look at the scale of atrocities that are taking place in the country. Of course, media rarely reports it, so we don't hear about it. in each of these cases, they had individual cases and individual facts before them. Courts, that was the takeoff point for the court to say, in our view, this is happening. What was the information before them? What was the material before them of this misuse? Nothing. It is true that courts hear a large number of cases on a daily basis. They can form a view on that basis. And they are hearing individual cases. It wasn't a public interest litigation. It wasn't a writ petition where material and information was marshaled before them from both sides to be able to see what is the use, what is, we could even ask, is it being used enough? I don't know. These are all matters of research, data collection, evidence. You do have the 243rd Law Commission of India report, which in 2012 says there is no empirical data to show misuse. There is the Law Commission. Now, Law Commission's job is to research, analyze, collect information, all the material required on a particular issue. Not when you are looking at an individual case and then draw a generalization, not only draw a generalization, but change the law on arrest, changed, in fact, Rajesh Sharma went to the other extreme and said, send these cases to the District Family Welfare Committee, which actually was nothing short of saying, go to the panchayat. And I don't mean, the panchayats don't only exist in villages. When I'm using the word panchayat here euphemistically, it means basically some people will sit around and, hear you out and tell you what to do. In fact, the composition of the committee was a telltale sign. It said there'll be some paralegals, there'll be some social workers, there'll be some retired persons and wives of working officers. I'm assuming they are male working officers, and therefore their wives have imbibed some knowledge through them, I would imagine. And it said they can be given the minimum training required. These are telltale signs. Because what are you really saying? Oh, come on, this is a ghar ka mamla where husband and wife are having a tiff. And so the elders can sit together. You can have, that happens in any case. In every mohalla it happens.
And the courts would take it up only if there's physical injury.
Yes. You have to be bleeding. If you're bleeding, then of course you've been raped, you've been murdered, everything is true. But you need to reach that point for the courts to believe you. Now let's just try and think this through. In my experience, limited as it is, I will not make generalizations, but have been doing and engaging with these issues both as a lawyer and as an activist for 30 years now. Women do not go to the police station the first time they suffer any form of cruelty. This I can say with absolute conviction and authority. I do not know a single woman in all these years who has, at the first time she has suffered grave injury of any kind, she has got up from her house and walked into a police station and lodged a complaint. Multiple efforts are made at the social level between the families, where she is counseled more than anybody else is counseled. Nowadays, maybe people are more progressive and they tell the man also to occasionally behave himself. Everybody around you counsels you, including your neighbor, the uncle, the aunties, everybody does that. It's only when things are beyond repair and there is no hope left in anybody changing their habits and conduct that things move forward. When things start moving forward, now which are the actors here? Because the discourse and narrative as it is being built, not just post Atul Subhash's suicide by husband rights groups, but also in the court. There seems to be this evil woman, the evil wife who is now wreaking havoc in the institution of marriage. She doesn't care about the future of her children. She just wants some huge amount. She wants to extract her pound of flesh. That's the picture that is being conjured of this woman. So are there women who may want to do that? They may well be. I do not subscribe to any theory that women are all angels or saints or devis. And why will they be? They're just regular people, right? Regular people are good, bad, ugly, indifferent, everything. When a woman goes to a police station to file a complaint, what happens there? There is the police. The police will record her complaint. We are sometimes told that the complaints are very vague. I think people should go to the police station and try and get complaints lodged. The police will tell you, don't write like this. Don't give me so many details. Oh, those details you can give later. Just tell me mota what has happened. And I will just write. So, and the police has its own script. In any case, as anyone who has read FIRs knows, FIRs are written in a lot of Urdu language is used. There is a script that the police knows. In that they fill in the blanks. If the woman were to take her own handwritten complaint, and if it is annexed, you may get details. Women can and will always give details, but they are actively discouraged. And that's the way the police works, and police also shirking work. Apart from the fact that they are like, this is not really a serious offense. This is something between you and your husband, and you're anyway going to resolve it 4 days later. Why are you wasting my time? That's the approach. We know that.
In fact, when my colleagues were reporting on the story that I mentioned earlier, they said they had spoken to multiple police officers. And at the time when a woman goes to the police station to file a case and it falls under 498A, the police will always add other sections to make the FIR stronger, make the case stronger,
So when
which will eventually fall apart.
So
is the system setting it up?
Yes, because then they say, oh, but you said that they asked for TV, car, fridge, but why would they ask for a fridge? They had 3 fridges in their home, but she probably didn't say that. That's why I'm saying they have a script. They're going to write that script.
So then the question is, who is actually misusing?
So then, should we pull up the cops? Should we train the cops? Tell the cops, learn to hear. And please write what she's saying. They'll tell you, madam, आपका केस नहीं बनेगा ऐसे लिखने से. आपको तो ये टीवी फ्रिज तो डालना ही है. And I can tell you for a fact, in fact, somebody did a study way back. If you were to pick up the FIRs relating to 498A in the 80s, they had 3 things written in them. TV, car, fridge. Every single FIR had it. It didn't matter which class of society the FIR was coming from. That's why I'm saying the script is pre-written there. Who are you now making this evil woman who is out here? The problem lies within the system. And the police, when it takes, let us say she has, so A, the embellishment is done at that stage. B, all 498A matters have to go for mandatory counseling. C, supposing I am making an exaggerated statement because I want to make sure that I'm taking my revenge on the family that has harassed me. When they will, surely the police will investigate. I mean, that's their job, the only job they have perhaps. So when I make a complaint, supposing I make some exaggerations. Now these are tangible things that are bought and gifted. How hard is it to investigate? You will need receipts. Even if you don't have receipts, you must have bought it from somewhere. The cop can go verify, did X buy? Do they have it? Where is it kept? These things don't disappear. These are all tangible. It's actually very basic investigation. It's not difficult investigation that we're talking about. If during investigation I find out that what has been told to me is not true, I will file a closure report and I will say there is no case made out to the court. Then it is up to the court. Now, if I don't do my investigation and I go ahead and file whatever somebody is saying, then the first check has collapsed. Why? Why did they not do their job? When it goes to court, court has to take cognizance. Now, if the material there does not show that there is an allegation which will stand scrutiny against, say, a sister-in-law, because there's a lot said, oh, you're implicating all family members, right? That there is a mother-in-law or a sister-in-law, then why does the court take cognizance against them? The court should say, I will take cognizance of the offense, and then at the stage of charge, you will discharge against whom no case is made out. So there is the police, there is the court. It's not as though this woman just walks in and the entire legal system then just whatever she dictates gets heard at every step. It's actually the furthest thing from the truth that my experience would show. Then you have this whole thing about, oh, but then why are there such few convictions? And then again, that brings up the host of false cases. Now, it's that same process which has the attrition is at so many levels that for a woman to survive, and it takes a long time in this country for any case to conclude. For you to appear at each hearing, for you to give your evidence, everybody in the family is telling you this is no good. Even if you were to leave this family, is anybody going to marry a woman who has filed a 498A case against her former husband? So, what are your marriageability prospects? Your family will tell you, don't pursue this any further. There's nobody who's going to support her, so she's probably going to back out halfway through and say, okay, I'm done. There will also be a lot of counter pressure from the husband and in-laws saying, let's settle the matter. What are settlements? Every afternoon at 2 o'clock, Delhi High Court has a large number of petitions which are taken up actually at 2 p.m. because the court has so much work. And at 2 p.m. they do what are called settlement, part of which are matrimonial matters. Because it's not a compoundable offense, you have to file a 482 petition. And how are settlements done? Some money is exchanged. Okay, if we have caused you harm and injury, we are now giving you money and the matter is settled. And you cut your losses. That doesn't mean that the cases that were originally filed were false cases. They are being settled in front of a court. So there is a narrative that is being built. But that narrative, if you break it down, actually there are other actors in the story who should each be asked what they did with respect to their statutory duties. And then there are reasons why cases don't go through. But the narrative of the evil woman, and commonly known that this is happening, actually has no substance.
I just want to go back to the Areesh Kumar guidelines, which was constituted in 2014, if I'm right, where the Supreme Court essentially gave out a list of guidelines saying that arbitrary arrests should stop, and only if the police meet specific conditions within the guidelines can arrest be made in 498A cases. A lot of activists, men's rights activists, or as you call them, husband rights activists, at that point celebrated this as a landmark judgment and said that this is going to deter the misuse of 498A. Did it actually deter the misuse, or what really happened with the Areesh Kumar guidelines?
So I think, again, Areesh Kumar, as I mentioned earlier, was an individual case where the court felt so we also need to factor in judicial anxiety here. And judicial anxiety, which is coming from a certain class and which is speaking to what people are observing in their homes of families feeling threatened by daughters-in-law. So the judicial anxiety it's lurking in these judgments. First, I think any arrest which is unnecessary should not be made. And I'm not only confining myself to 498 here. I think in this country, people are being arrested, whereas the investigation does not need the arrest. And the court the principle is correct. You may have the power of arrest, but is there a necessity of arrest? What is your justification for arrest? And that principle has now been carried forward, not just for 498A, but any offense which is punishable for less than 7 years. Across the board now, Supreme Court has repeatedly said no arrest is to be made, serve a legal notice and question the accused, which is a sound principle. But coming to 498A, it actually, in fact, in 2012, the Law Commission had said that we don't see any reason without empirical data to denude the provision of its teeth. What are the teeth of the provisions? The teeth were of arrest. People fear arrest. In principle, I think it's fine if you can actually conduct an investigation and restore Stridhan. That is very often the contentious issue there. That the Stridhan, which is the woman's jewelry, etc., is in the control and custody of the in-laws. And on that ground, people would return, etc. Now, if you can get all that restored, if you can do the investigation, that's fine. Whether it has deterred misuse, I mean, first we'll have to establish misuse. So I'm not going to start speculating on something which I don't think anybody has established. Has it been effectively used? Is it underused? Is it misused? Are the lack of convictions on account of a host of other reasons that women are not being able to stay the course of the legal journey? Has the provision served the objective? Are women today not being harassed for dowry? Are women not being treated cruelly for other reasons? The data is showing something else. So we have here a lot of issues that open up. Again, when it comes to arrest or misuse, the Supreme Court itself has said in so many orders and judgments by now, UAPA is being misused. PMLA is being misused. I don't hear anybody saying, let's bring it down, or, this evil state, what is it doing? So that's why I'm saying there is a different judicial anxiety, which is stemming from our own social location.
Yeah, and this, I think the court sort of exposed this judicial anxiety in itself in the 2017 setting up of the Family Welfare Committee, right?
Which was quickly then overturned by the Supreme Court itself.
Yeah, so Justice Deepak Mishra eventually struck it down.
Absolutely.
But the philosophy of it kind of originated from this idea that the structure of the family supersedes safeguarding individual rights. Now, even though it was struck down, you said it earlier before as well, do you think that philosophy still continues to breathe through the system? And in what ways at the judicial process are women told to go back to their families? And I mean in the courtroom, not by families themselves asking women to, adjust, or this wear and tear, like you said,
Absolutely.
right?
So, I mean, it's basically, this is patriarchy.
Yeah.
It's how patriarchy, I mean, what does patriarchy sit on? So this is patriarchal culture. Philosophy would be an elevated, dignified way of describing it. It is patriarchal culture. It's how patriarchy is rooted. And individual rights matter. It's not about individual rights in the family. It's about women's rights, where women are now seen to be assertive, independent. What are women claiming? They are claiming to be treated as human beings. Human beings are not to be treated with cruelty. Actually, neither are animals. Women have always been subordinate in our pyramidical vision of the family. And today that structure is undergoing a change. And the law stepped in to ensure that change was made accessible and available. Courts are very, very deeply invested in saying families must be maintained and marriage must be maintained. It is true that there is there is a polyvocality even in the court today. So court is not speaking, and I'm talking of the Supreme Court here, is not speaking in one voice. But in that polyvocality, the idea that do whatever you can to ensure that the family and the marriage does not break. There is a huge investment of time and ideas there from the court. I would offer another way of thinking about it. And the court very often says, oh, we are doing this because, children think about the children, what will happen to the children, and children growing up in a what is called in quotes a broken home, and it is for their future that we are trying to bring the two parties together. Just a couple of things we need to think here. One, any psychologist, psychiatrist will tell you, children observing violence in home, this is perhaps the most detrimental impact it can have on the child's psychology and the likelihood of the child repeating that pattern in their own life. This is all documented. This is not so. I think we need to educate ourselves. Children are better off in non-violent homes with parents separate. It's all right. They understand and learn. Secondly, this whole thing about making the institution of that family and marriage is the basis, the fundamental unit of our society. Can we have a non-negotiable principle that any family or marriage where there is any form of violence, be it physical or mental, that family or marriage should not be preserved? Family and marriage are not abstractions. They are real people in that real social unit. Very often it is the violence that the law is condemning, nothing else. So if that violence is going to be the basis of, and the woman has to endure it or live with it, even for the sake of children, why should she? Why is the court not repeatedly asserting that marriage and family will be, we would like it to be reinforced as long as violence is non-negotiable in any form? We don't hear that loudly and clearly. So we actually, there is you're reinforcing certain regressive patriarchal ideas repeatedly. And when so I think we need to re-envision marriage and family. And I think the marriage equality petitions that came before the court, I was representing lesbian and trans persons through a petitioner called Rituparna Bora and others. We were talking about how violence is inherent in the natal family if you're of a different sexual orientation or gender identity, and how they needed the protection of marriage. But there, the court declined, because their marriage would have shielded them and protected them from natal family violence. So what we are observing is that whenever individuals, for different reasons, are making different choices, be it of sexual orientation, gender identity, a woman refusing to accept patriarchal violence and culture, when those are being questioned, the court is reinforcing a very conservative, regressive, patriarchal idea of the family and marriage.
We've spoken about the courts, we've spoken about how families deal with women and especially with violence at home. I want to ask you a little bit about the media. I know that you don't watch a lot of television, but how do you think, when we look at the debate around the Atul Subhash case, and you've been dealing with this for a very long time in courts and the media, how do you think the media really has addressed this issue? And are they really addressing the issue, or has it become a debate that keeps arising like this?
See, I think media, it's also a process of the media is not one homogeneous media anymore.
Of course, yeah.
And within the media, there are those like yourself who educate themselves and think about it and talk to people to understand issues. Sometimes the media is very much like the court. They seem to know everything about every issue. Whether it is a cheetah in escaping from Kuno, or it is rape, or it is 498A, they have a view on everything without ever having thought about it or talking to people who've engaged with the issue or worked on the issue. So I think, one, there is a problem in the media where they are expected to write and know about everything. So that's probably a professional hazard they deal with. In the 80s, when the issue of dowry death, bride burning, and cruelty under 498A, these laws came about because the media showcased the violence against women. The media played a role in highlighting what was happening behind closed doors, because what happens inside a home is not known. And the media played that part, and every day the newspaper carried stories of what was happening, which then society understood that we needed to do something about it. Similarly, if we look at the issue of what happened in 2012, I think the media was also on when the gang rape Nirbhaya took place, the media was on a fast learning track. Of course, it fumbled and still says foolish things around rape non-stop, but I think there is a marked change you can see in the way in which media writes about it. And I think the presence of more women in the media has markedly changed the discourse around these issues, particularly around gender-based violence. Insofar as the Atul Subhash thing, as I mentioned earlier, I think the narrative is still controlled by men. Because, for me, the figures are so startling. And as I said, Atul Subhash's death is unfortunate and tragic. There is no doubt about that. But to posit it and to exploit it and to conceal that 17 to 18 women are dying due to dowry in 2022 in India, why is the media not posing these two as lived realities of this country? And now it's become as though there are, that's what I'm saying, suddenly it's these evil scheming women who are being lying and who should have no legal rights. Whereas all around you, you're seeing dowry is not diminishing. And in our homes, we know that it continues to be a practice. So where is it that we strike that balance where, yes, there will be issues which will get highlighted and sometimes media gets drawn into it, but I don't find the media playing that role where they need to create, media's idea of a debate is very strange. They think a debate means there has to be a head-on collision between two views. That's not a debate. A debate is an engagement where you engage with what the other person is saying and you try and both understand and challenge. I don't find media does that at all. So it doesn't contribute to our learning. We are all learning as we are hearing. Media is not contributing to that learning. It is then reinforcing certain things, and very often you need to go and do your homework. You maybe need to travel, definitely outside the city, or go to parts of the city that you don't usually visit. It's also all become, what can I get easily? So we are not, media, surely individuals or the court is not going to go and dig up all the stories. That's the job of the media. There's very little of that is done, and media doesn't stay with an issue. You cannot, Atul Subhash issue has not dropped from the heavens on us. Unless you go back to what was happening in the 80s, and now it's all digitized. How long does it take to open the newspapers of the 80s and see what was the social context in which 498A was brought about? Where is that research? Where is that historicity of your debate coming in? Everything can't be decided today. X has happened, we'll change this law. Tomorrow Y will happen, we'll make this gender neutral. It's these are just silly reactions that are coming. We are not engaging.
And I actually want to end on this question when we are talking about all the ways in which the courts, whether it's the family, whether it's the media, continuously engaging with this anxiety. Right? It is an anxiety that has recurred over time in various formats. And once again with Atul Subhash's case, that there's been misuse, the alimony issue, that women are extorting money, that they're being vindictive. For you, as someone who is engaged with this issue for so long, what do you think it tells us about the times that we're living in? What does this anxiety really reveal to us?
I think two things. Before I go to the final question that you've put, I just want to mention on the alimony, because that's a big part of the Atul Subhash conversation. And there's this gold digger woman and the woman who's extracting all this money from the in-laws. And, there have been another suicide again saying, because they're asking for money. So, of course, we don't seem to comment on dowry anymore at all in this country, although dowry is being given. Now people even splash the dowry they give without any shame. There's not even a social stigma attached to it that you'll do it behind closed doors. How does alimony get decided? How does maintenance get decided in this country? Courts decide. There are set principles. There are set procedures. There is a judgment, Rajesh versus Neha, which says both parties will file before the court an affidavit of assets and liabilities. Now, if you're filing it on affidavit, you better be telling the court some truth, otherwise you're in trouble later.
Yeah.
And the other party probably will know what you have or don't have. On the basis of that and on the basis of set principles, the court decides alimony. It's not as though I can walk into court and say, I think that I should get a maintenance of 30 lakhs a month and a house and a car, and I need for my permanent alimony, I need few crores.
Yeah, but that's the allegation that women are just
So I may
extorted.
make that.
Yeah.
I may say that in court. I may put it in my application, and my lawyer may well be egging me on. I mean, lawyers are egging on men and women to write odd things in petitions. I'm not going to hold a brief for lawyers who are doing that. It is true that lawyers do mislead their clients sometimes. Some lawyers, not all lawyers. But when you have, you may make that claim. The court is not going to grant you that alimony. The court is going to go by rules and principles which have been set in law. And there are multiple precedents the court is going to follow. So to say she asked for it, I can ask for the moon. How does it matter? Nobody is going to get it. So there is a court which is deciding. That's why I'm saying this conversation is taking place, that there are these evil, wicked, scheming women who are out to destroy the family, wreck the family, put the in-laws behind bars, which you cannot arrest anymore, so I don't know what that is about, and to take every penny out of that poor, hard-working man. Two things here. One, as I said, it's decided by law and court. Secondly, why is there no conversation around matrimonial property, matrimonial resources in this country? After all, even in this case, there is a child. So let's say the marriage would have at least been for 5-6 years, if not more, I don't know. The man is clearly working. I don't know if the woman is employed or not, or was working or not, I don't know. But, and when I say working, I mean drawing an income from outside the home.
In this case, I think she was working.
Okay. But there is a home. In 99% of homes, the labor in running the home, even if you are going to be a couple that is hiring further help, domestic help, still there is labor in running the home. There is social labor. There is labor of care, which we saw in COVID. There is labor of reproductive labor. All that labor, what is its quantification? Is there any value we attach to it? Supposing I'm not working outside, I'm in the home, I'm running the home, I'm keeping the home going, which is how the lunch gets packed and children get to school and men get to work. Where is that labor valued? Why is it that we have no conversation when we say, how does the media report? I find these as such important opportunities to be having this conversation. Do we have a law relating to matrimonial resources, which are then to be equitably distributed in the event of dissolution of marriage? Where is that conversation? Where is the matrimonial property? Where is a conceptualization of irretrievable breakdown of marriage? If somebody wants to get out and the other person is using, let us say, some women may, out of anger and rage, want to say, okay, I will never let go of you. And I've seen this, it's not unusual. It's because you're so full of rage. And it is true that social consequences for men and women post-marriage are different. Her prospects and his prospects socially, there's a world of a difference. So she may say, I'm not going to let go of you. You have ruined my life, I will ruin your life. This is said. I'm not denying this. Where is the law on irretrievable breakdown of marriage? Why is that conversation not happening? It's been discussed. Why are we not taking that forward? So there are all these missing gaps in the conversation that we are not taking forward, and it's become one as though, there are poor men and there are these evil women, poor husbands and evil wives, and this is a no-brainer in my view. And all that is going to happen is that regressive patriarchal culture is getting further reinforced in this conversation. But to return to what
the anxiety reveals.
Yeah, so the anxiety does reveal a change. And change will happen. And change is happening. Does the family look the same as it looked in my grandmother's time? Absolutely not. And thank God, no woman would want the family to look the way it looked in her grandmother's time. And with each generation, that push towards equality, that push towards respect and dignity will increase manifold. Will society embrace the change willingly? Usually not. Are those in places who can form this opinion? That would be the media, that would be the court, that would be our social and religious leadership. Are they helping people embrace this change? No. Because they are holding on to, they are actually expressing the same anxiety. And they are fearing the change. And, so it's a lot of what is being said today is actually that change towards embracing the other person, not as a subordinate in the relationship, which is what you've been, how marriage has been conceived, the whole Hindu rituals, which are commonplace everywhere. Everybody performs those rituals, even so-called people who are, literate and understand. The whole ritual is based on the woman's subordination and the woman then accepting the husband as her lord and master who will tell her how to live a life. Yes, people don't actually do it. I'm not saying they actually live their life like that. But why are we perpetuating these things?
Even symbolically.
Yes. Yeah. So yes, the fear of equality, the fear of giving anybody equal respect and dignity is the fear of change. And let's not forget even for a minute, this country is deeply embedded in caste. And casteism teaches us discrimination and violence. That is, those are the two things we have learned from caste. And caste and patriarchy intersect in this country. How do we as a country emerge from that when we don't have either institutional or individual leaders who are encouraging us to go down that route?
Thank you, Vrinda. Thank you for this conversation. I think this was very informative and much needed in this particular debate around the misuse, so quote-unquote misuse of 498A. Viewers, thank you for listening in. Such long-form interviews and reportage. We've done a bunch of stories around this particular case on the News Minute and newslaundry.com. You can go and listen, watch and read these stories. So please do subscribe to our channel so we can bring you such nuanced conversations going forward.